All right, good evening. I'm your lawyer, Patrick McGee, and I am your best friend at your worst time. People are going absolutely nuts over this case. This is a case we talked about Monday on our Monday update, as well as Wednesday on our Law and Life Live. It's the case of the South Florida ER doctor who lost custody of her daughter because she's an ER doctor. People were emailing me and calling the office asking how this can happen. How did it happen? Can it happen to me? Well, I'm going to address that now. I had so many inquiries on this and questions about this. They asked me to do a video, so here it is. Okay, so on April 8th, in this particular case, which has been going on since 2018, the father filed a verified emergency motion to enforce Administrative Order 20-6. That's the order, the administrative order from the courts that requires you to follow the parenting plan and the final judgment in place unless it becomes unreasonable to do so. To temporarily modify time sharing due to the mother's significant heightened exposure to COVID-19 and to award the mother equivalent makeup time sharing when the state of emergency is lifted. Okay, so what does this mean? What does an emergency order mean? Emergency motion mean? Emergency motions deal with whenever there's a threat to a child, life, limb, injury, detriment, one parent going to flee the jurisdiction, something like that, some type of imminent danger to the child, and something that's a detriment to the child. You file the motion, you make your allegations. It says sworn, it says verified. That just means that it's been notarized under penalty of perjury and the father stated it to be true. In his motion, he states the mother is an emergency room physician and she is treating COVID-19 suspected patients and confirmed patients on a daily basis. Mom works at Memorial Hospital, which is one of our big hospitals here in South Florida. She is an ER doctor. He goes on to further state, there is no question the mother is significantly higher risk of contracting COVID-19 since she is an emergency room doctor and exposed to the deadly virus on a daily, if not hourly basis. Further, there is no question the mother's continued exposure to the minor child is detrimental to the interest of the minor child, and at this time, to continue to facilitate time sharing between the father and the mother until the pandemic state of emergency in Florida is over would only severely expose the minor child to the deadly COVID-19 virus. It's speculative. Mom's working with COVID-19 patients. She could contract the virus. She could not. He's not alleging that she did. Doesn't appear that she has. It's speculative. So he files the emergency motion. The judge takes up the motion, reviews the motion, does not have a hearing on the motion, and issues an order suspending mom's time sharing based solely on the fact that she's an ER doctor, she's treating COVID-19 patients, and she could be exposed to the COVID and therefore expose the child to the COVID-19 virus. Very shortly thereafter, the third DCA got involved. I'm guessing it was because somebody filed a notice of appeal in a brief, although I did not see the notice of appeal in the trial docket, and I could not find anything on the third DCA site. I'm going solely off the reporting of NBC6 News in South Florida, which is reporting as of, get it up here, as of 2 days ago, that the appeals court rules in the favor of a South Florida doctor in custody battle. The Court of Appeals issued an order staying the trial court order. So what does that mean? It means the Court of Appeals, which is a higher court than the trial court, says, trial court, we're holding off and we're suspending and we're staying your order on this custody issue. I checked the docket again. Shortly thereafter, the father filed a motion requesting the trial court vacate that order. So can this happen to you? We were all wondering about that. It has come up in cases. It's come up in several of my cases because I represent a lot of policemen and firemen, or police officers and firefighters. I represent a couple nurses also. And it has come up, and fortunately in the cases that I'm dealing with, we have been able to work it out. These are different times. These are strange times. We're going places where we haven't been before. And I have found in my cases that additional direct frank communication between the parties and going above and beyond to facilitate and to consider changes in time sharing, changes in routine to best facilitate time sharing between both parents has worked in our cases. None of our cases have reached the point where we've had to go into court on an emergency order. We've been able to negotiate agreements between the parties, and they are working at least to date. Apparently, this wasn't the issue in this particular case, and it blew up, made the news down here, and people were just going nuts about it until the third DCA stepped in and stayed the order. So a quick rundown on the procedures. You file the emergency motion. It's notarized. The judge took it up. There was no hearing. The mom didn't get to come in and argue her side. The judge issued an order, it appears, just on the motion itself. And then the mom filed her response and several motions directed thereto before the third DCA stepped in. The normal procedure, that is a normal procedure for emergency motions. If the judge deems an emergency and deems the contents and the basis of the motion to be sufficient to warrant an emergency judgment, they will take it up on an ex parte basis like that and go solely off the motion in hand. The problem with this particular motion is the basis was solely for possible exposure and the child's possible exposure to the virus. The third DCA, from what I understand, speaking to other lawyers and from what I've seen in news articles, the third DCA is basically saying that alone, that basis that the child could possibly be exposed to the coronavirus because mom is an ER doctor, that basis alone is insufficient to suspend time sharing, because there are procedures and training that these doctors are having, that first responders have, that train them on how to deal with this, safeguards that they can take to prevent them from coming into contact with the virus and contracting the virus directly from a party and therefore taking it home and infecting other family members. There's been a bunch of articles about, cops and firefighters and all that sleeping in their cars outside their house and in their RV. We just had a case the other day that made the news where a guy was traveling extensively for work, meeting a lot of people, and he parked his RV in front of his house to live in so he didn't infect his family. He was taking that precaution, probably a little overboard, but he was taking that precaution on his own, and his neighbors were going nuts. They were contacting the police, they were contacting building and zoning in the city, and they were contacting the landlord who owned the house trying to get the RV out of there. And in that case, the city of Coral Springs go, no, considering the circumstances, we're going to let him stay. So can this happen in your case? Up until now, we didn't really know. We suspected it could happen. We thought it might probably happen. And I'm talking about we as lawyers. This is the only case I've heard going in on an emergency motion. There may have been others. Like I said, we're treading in new territory here. We had an idea how the courts would take this and what they would do, but we really weren't sure because it's kind of seat of your pants lawyering at this point due to this environment and because of these circumstances. But now we now know that just because you're a first responder, just because you're a police officer, a firefighter, a nurse, or a doctor, that is not sufficient, at least in the third DCA, for your time sharing to get suspended. They need more to suspend time sharing than that sole basis alone. So that should take care of it, unless something comes up where something else forms the basis for it. That should put this to rest, but you just never know. If something like this happens to you, or there's discussions with you and the other parent or the other party in your case about these types of issues, you should contact a lawyer immediately if you don't have one. If you do have one, feel free to contact them and go over these issues with them to avoid any problems. Like I said, the more intensive communication between the parties and the urging the parties to go above and beyond in their consideration has worked in our cases, and it'll probably work in yours too, but at least try it. because going to court should be the last move. You should always try to work these things out yourself. I hope that answers everybody's questions. I got a bunch of emails and DMs on it, and I couldn't answer them all individually. So I hope I covered them all in here. I reviewed a bunch of them before I went on, and I think I got them all. But if I didn't answer your question specifically, feel free to email me at patrick@pjmlawyer.com or to DM me on any of the social media platforms that I'm active on. They're all listed in the description down below. And I will post a link to the latest article describing the action by the 3rd DCA from NBC 6 Miami down below in the description also. Have a good night. Stay safe. Remember, we're all in this together. We'll all get through it together, and hopefully it'll be over soon. Be kind. Be considerate. If you can help somebody out, do it. The good karma will come back to you many, many times over. I promise you. Good night.